Open Secrets and the Unpaid Benefits Campaign, represented by the Centre for Applied Legal Studies, have approached the Gauteng High Court to set aside a set of provisions under the financial sector regulations. This is the second part of a two-part process we started in October 2020. Here is a clip from last year of Open Secrets' Head of Investigations, Marchant, talking about the importance of the regulator of the financial sector and discussing the first part of our litigation.
Financial Sector Conduct Authority, or FSCA, is the first regulator in South Africa to be a dedicated market conduct regulator in the financial sector. And what that means is that it's the first time that South Africans have a regulator of financial institutions that is dedicated to protecting them from unfair practices and other discrimination by those financial institutions. And so it is the job of the FSCA to make sure that banks, insurance companies, pension funds, and pension fund administrators are treating their customers fairly and treating them equitably. And this is one of the reasons that who heads up the Financial Sector Conduct Authority is so important, and why public participation in that process is absolutely vital, given that it is the public interest that regulator serves. The leadership positions in public institutions and regulators of the financial sector are absolutely essential. And that's why we think that who is appointed to the commissioner and deputy commissioner positions of the FSCA are so vital. It's really important to remember in this context that the FSCA's sole mandate is to regulate very powerful financial institutions that have a lot of weight, they're very wealthy, and they push back very hard against attempts to regulate them in order to make sure that they treat customers fairly and that they're obeying the rules in the financial regulations. And given that the FSCA comes up against such powerful pushback from the private sector, it's even more important that the people appointed to leadership positions there show integrity, but also show the tenacity and the desire to fulfill that public function and fulfill the public interest in their role at the regulator. And that's why, again, we've demanded that this process is fully open and transparent, because we think that we as the public, given that we are the ultimate beneficiaries of the conduct of the regulator, we should be able to have insight into those who are being appointed to lead it and make our own decisions as to whether they are fit to hold that office. The appointments process for the leadership positions at the FSCA have in fact been ongoing since April 2018, when the regulator came into existence. And the public was told at the time that the appointments process should be wrapped up before the end of 2018. And so one of the concerns that Open Secrets and the Unpaid Benefits Campaign have had for quite a long time is the delay in making the appointments. And so Open Secrets has been writing to the minister since April 2019, both to inquire about the delay, but also to push the minister to commit to opening up the process. And we've had a few simple questions throughout, namely, will the media and the public have access to the process? The ability to listen in and watch the interviews? Will we have access to the CVs? And will possibility be made for input into the process from the public? As I've indicated, we've been writing to the minister since April 2019, and 4 letters in the intervening period have been sent, acknowledged by the minister's office, and not once has Open Secrets received a response. As a result of the refusal to engage with Open Secrets and the Unpaid Benefits Campaign on this issue, the organizations have been left with no choice but to approach the court to try and demand an open process. And so we have gone to the court on an urgent basis to ask that they halt the process, the appointments process, until such a time that the minister makes the provisions for the very simple request that we have made, that the interview process be fully opened up to public participation and media presence, that the CVs of those candidates are shared, and that the appointments process, both from an interview but also a shortlisting perspective, are made fully available for public scrutiny throughout and not just after the fact.
Now we hear from Open Secrets' investigator, Mathe, about the outcome of the first part of the litigation, which Michael was explaining. Zen also talks about the second part of the litigation, which is set to be heard in the Gauteng High Court today on the 13th of May, 2021.
In November 2020, Open Secrets and the Unpaid Benefits Campaign had applied to the High Court for an urgent interdict, the first part of our application, halting the appointment of the Commissioner and Deputy Commissioners at the FSCA until the appointment process allowed for meaningful public participation. Unfortunately, Judge E. van der Schyff decided against our application, saying that public comment on the selection committee's recommendations is sufficient and that we should have used the Promotion of Access to Information Act, known as PIA, to get the relief we sought. Respectfully, we disagree with Judge van der Schyff and maintain that public appointment processes should facilitate meaningful public participation. This means being able to participate in a transparent appointment process before any recommendations are made to the minister. We also disagree that members of the public need to use PIA, which is intended to access records and which is different from seeking a transparent appointment process. While we fundamentally disagree with Judge van der Schyff's reasoning, we decided to proceed with the second part of our application. Therefore, Open Secrets and the Unpaid Benefits Campaign approached the Gauteng High Court, asking the court to review and set aside the regulations insofar as they do not provide for meaningful public participation and transparency in the appointment process. We are not asking for the recent appointments to the FSCA to be set aside, as that process was already hugely delayed by the minister. Instead, we seek a forward-looking decision that declared for all future purposes that meaningful participation is required, which is more than a retrospective tick-box exercise. The public must be afforded an opportunity to meaningfully engage and influence decisions. Minister Mboweni, though he might not want to engage with the public he serves, must do so as a constitutional check on the exercise of his power as a public official. The public is not passive. We have a voice, and Minister Mboweni is constitutionally obliged to listen to us and apply his mind to what we have to say. He cannot delegate or outsource this. It is unfortunate that Minister Mboweni chooses to only engage civil society through court processes. We hope that this litigation will change his mind generally about how he engages with the public, and specifically about how he makes appointments and acts in the public interest. As the Zondo Commission has shown with devastating clarity, we cannot and should not simply trust public officials to act in the public interest, and that secretive appointment processes have catastrophic consequences for people in South Africa and our democracy.
You can find out more about our court application by visiting opensecrets.org.za/FSCA-interdict, or follow us on Twitter, Instagram, LinkedIn, or Facebook at Open Secrets ZA. I am Mamello Mosiana, and this is Open Secrets Radio.